Hello everyone, I'm Debujit Das and you're watching Courts Today by LiveLaw. We track the pulse of India's judiciary, breaking down key judgments, observations and legal shifts that matter. Today's docket includes a deep look into UAPA bail jurisprudence, digital identity, political accountability, gender rights and, believe it or not, the concept of brain death. So, let's begin. In a politically sensitive matter, the Supreme Court has asked the Union government to reply within 3 weeks to a public interest litigation that seeks a court-monitored SIT probe into the awarding of public contracts in Arunachal Pradesh. The present petition accuses Chief Minister Pema Khandu of gathering large-scale contracts, some without tenders, to his close relatives and business associates. The petition, represented by senior advocate Prashant Bhushan, argues that this violates constitutional norms of transparency, arbitrariness, and creates a mockery of public interest safeguards. The centre had earlier submitted that proper procedures were followed, but the bench was unconvinced, refusing to dismiss the case outright. This is an interesting development to track as it probes whether executive decisions, even at the state level, can be judicially reviewed when they show signs of institutional nepotism or conflict of interest. The court's next move could shape the conversation around clean governance. Next, we saw that the Supreme Court has issued notice on a bail petition filed by an individual accused under the Unlawful Activities Prevention Act. This individual, who has spent over 5 years in custody now. The accused, allegedly affiliated with the Tritiya Prastuti Committee, is charged with extortion and levy collection from local contractors in Jharkhand, with prosecution invoking provisions from both the Indian Penal Code and the UAPA. The defense leaned on Union of India versus K.A. Najib precedent, where long custody and lack of trial progress were deemed violations of personal liberty. The Jharkhand High Court, however, denied bail, distinguishing Najib due to the lower number of witnesses and the gravity of armed insurgency charges in this case. But the Supreme Court's decision to issue a notice may signal a growing discomfort with the indefinite pretrial detention, even under special statutes like the UAPA. The case continues to raise foundational questions around Article 21, presumption of innocence, and how national security laws interact with personal liberty. Moving on, calling it a clear case of judicial impropriety, the Supreme Court has reprimanded the Kerala High Court for modifying bail conditions in a case where the original bail order was already under challenge before the top court. The accused, out on anticipatory bail, sought permission from the High Court to travel abroad. Despite knowing the matter was sub judice before the Supreme Court, the High Court actually permitted it, prompting strong disapproval from the bench. The Supreme Court cited the decision in Chhavi Mehrotra versus Union of India, reaffirming that once a matter is before a higher court, lower courts should refrain from actually passing orders that impact ongoing appeals. The modified condition has been struck down and the court has now issued a notice asking why anticipatory bail itself should not be revoked. This judgment reasserts the need for hierarchical discipline in judiciary, particularly in cases involving personal liberty and criminal procedure. In a high-profile case on digital identity rights, the Delhi High Court has stepped in to protect Aishwarya Rai Bachchan's personality rights, restraining the unauthorized use of her image, name, and likeness, especially through AI-generated content. The actress had approached the court alleging that various platforms were selling morphed images, intimate fake visuals, and even commercial merchandise like mugs and t-shirts, all without her consent. Some content was sexual in nature and intended to generate online traction using her identity. The court noted the precedent set in Anil Kapoor's case and affirmed that personality rights remain enforceable even in the absence of a codified statute. A total of 151 links will be included in the forthcoming order, with interim injunctions to be issued against the infringers. This order expands the judiciary's emerging recognition of the right to control one's digital persona, an area rapidly complicated by the rise of AI tools and deepfakes. During the peak of the COVID-19 pandemic, Ramdev Baba's comments calling allopathy a stupid science created nationwide uproar. Multiple FIRs were filed, but now the Chhattisgarh police has filed a closure report in the final pending case, citing a lack of prosecutable evidence. The Supreme Court, which had earlier consolidated all FIRs for hearing, noted that with this closure, the matter essentially stands resolved. The Solicitor General also informed the bench that there was no malified intent and that no cognizable offense could be actually sustained. The case touches on important themes of free speech, especially when statements intersect with public health discourse, misinformation, and scientific temperament. For now, though, the court appears inclined toward finality. Moving on, the Allahabad High Court has granted bail to Sarfaraz Ansari, an alleged long-time aide of Mukhtar Ansari, in a case related to the 2001 Usri Chatti murder. What's interesting here is that this was the second FIR filed on the same facts, but 22 years later. The complainant had filed an FIR in 2023 alleging that the informant's son had been killed by Mukhtar Ansari and his accomplices on July 14, 2001. On being questioned about the delay of almost 2 decades, the informant stated that he lost the FIR in 2023 because that was the time Ansari finally ceased to be an MLA. The court, however, flagged serious procedural concerns, delay, multiplicity of FIRs, and potential double jeopardy. With no substantive progress and no trial concluded after 2 decades, the court found that continued incarceration would be an abuse of process. Moving on, the Delhi High Court has clarified an important position of law in matrimonial disputes. A wife is entitled to maintenance even if she's the one who initiated divorce proceedings. Rejecting the husband's argument that the wife had voluntarily walked out of the marriage and thus was not entitled to any financial support, the court ruled that Section 125 of CRPC is a social welfare legislation meant to protect those who lack means and not punish them for asserting marital autonomy. The rule reflects the judiciary's continued emphasis on economic protection for women in broken marriages and avoids reducing maintenance to a reward-punishment matrix based on who filed first. In an unusual case, the Supreme Court has begun hearing a petition filed by a doctor challenging the very concept of brain death as defined in India's Transplantation of Human Organs Act 1994. The petitioner argues that the law's criteria for declaring a person dead is ambiguous, and that equating brain death with legal death may actually violate Article 21, especially when decisions involve organ harvesting. The court admitted that it found the legal medical complexity quite challenging and that it may need expert guidance before taking a definitive stand. It could be a landmark case in the years to come, pitting medical ethics, constitutional morality, and religious interpretations against public health and organ donation policies. And that wraps up this week's Courts Today from LiveLaw. We'll continue tracking these cases as they evolve. For deeper analysis and full judgments, head over to www.livelaw.in. I'm Devojit Das. Thank you for watching.